our General Counsel, Mark Silverman, is going to talk to us or make a presentation for us.
Thank you, Commissioners. Mark Silverman, General Counsel. Commissioners, I would like to give you a brief overview of the hardship process in light of the recently filed West Park Presbyterian Church hardship application. This will be a general discussion of the nonprofit hardship standard that will be used in this application and the process as set out in the landmarks law. I will not and ask that you do not discuss the West Park application. Also, please note that to make the law and process as clear as possible, I have tried to minimize my use of legalese and have simplified some of the things and used different terms. Ultimately, review of any particular application will involve the application of specific words in the statute and be a highly fact-sensitive inquiry. Let me make sure. Cannot be overstated how important the hardship provision is to the landmarks law. The law has always included a hardship provision. It's codified in section 25-309 of the Administrative Code. It's the longest section by far in the landmarks law. It is an absolutely critical safety valve for the law because it seeks to prevent the law from being applied unconstitutionally. The hardship process is a type of application, just like a C of A. And the law provides standards and a process, and that's what I will be discussing. What is meant by a hardship? Well, hardship describes a situation where a property owner wants to perform work, either alterations or demolition, that the commission finds or the applicant concedes is inappropriate. The owner claims the inability to do this work imposes an undue burden on their property. The hardship process in section 25-309 is the way the commission determines whether the inability to do the work actually imposes an undue burden. The concept of hardship arose historically as government regulation increased during the late 19th and 20th centuries. It is related to the constitutional prohibition against a state using private property for public purposes without just compensation, known as the takings clause. As government regulation increased, courts were repeatedly asked to decide when a government regulation went too far and was akin to a physical taking in its restrictions on use and therefore required either compensation or freedom from regulation. The hardship provision in section 25-309 is the way the drafters of the law sought to avoid constitutional challenges to the law. Hardship applications are rare, but have occurred periodically over the 60-year history of the commission. I believe their relative rarity is due to how hard the commission works with property owners to accommodate reasonable needs. There's been 23 applications, hardship applications in the past 60 years. The first one in 1967, the Jerome Mansion, was granted. The last 3 applications, hardship determinations, were city and suburban houses in 2014, a for-profit hardship where the hardship was denied. St. Vincent's Hospital in 2009 was a nonprofit hardship where the hardship was granted, and St. Paul and St. Andrews in 1989, which was a nonprofit hardship but was denied for not being ripe for a technical review. Of the 17 applications of these 23 that went through a full process, 13 were determined to be hardships and 4 were determined not to be hardships. The law provides 2 types of hardship processes, one for property that is exempt from real estate taxes. That's what we're calling the nonprofit hardship process. And then there's another one for all other property which is not exempt from real estate taxes. The presentation today is just focused on the nonprofit hardship process. Turning now to that test. Section 309 requires an applicant to satisfy 4 factors. The owner has agreed to sell or lease the property contingent on a certificate of appropriateness or a notice to proceed. The existing property is incapable of earning a reasonable return. The building is no longer adequate, suitable, or appropriate for carrying out the current or the historic charitable purposes. The purchaser seeks to immediately demolish the building and to build a new building on the site with reasonable promptness if a hardship is granted. I will discuss each of these factors individually. First factor, the owner has agreed to a contract to sell or lease the property. In this case, the lease must be for at least 20 years, and the sale or lease is contingent on the commission issuance of a C of A or a notice to proceed. In other words, the agreement is contingent upon a positive outcome in the process. Either the commission says the work is okay, and issues a C of A, or it determines a hardship exists and issues a notice to proceed. I will discuss the notice of proceed later. It's the final document authorizing work, inappropriate work to go forward once the hardship has been determined. The second factor asks whether the property as it exists at the time of the application is capable of earning a reasonable return during the specific test year. Reasonable return is a statutory formula defined in the law. It's not what a property owner or a real estate developer would utilize in managing property or when considering purchasing property. At its most basic level, net annual return is a cash flow analysis. It is defined as the net annual return of 6% of the valuation of an improvement. These are defined terms in the law. An improvement parcel is basically the tax lot, which includes both the land and the improvement, which is usually a building. Valuation is typically the assessed value of the tax lot as established by the Department of Finance. The net annual return means the amount the earned income yielded by the improvement parcel exceeds the operating cost. So for example, if the assessed value was $1 million, the property has to generate a net annual return of at least $60,000 during a specific test year to generate a reasonable return. So how does one derive this net annual return? One looks at the operating costs and the income. As I said before, it's mostly a cash flow analysis. Operating costs include your typical inputs: payroll, utilities, taxes, professional services. There's a 2% depreciation allowance for the value of the building. It's also important to note that what's not included in this, and that includes things you might expect, such as mortgage payments, amortization reserves. They're not included as operating costs. Moving to the income side of the equation, income means proceeds from the use of the property. Proceeds typically include rent or other income from use. An example would be if it's a residential building, are they renting, is there laundry facilities or storage facilities that people are also paying for? Can also include the potential sale of development rights, assuming there are real potential receiving sites to receive these development rights. That includes as of right zoning lot mergers, as well as special development right transfer provisions under the zoning resolution, such as the one we were just looking at today. Typically, you would look at the commission has looked at whether there are reasonable receiving sites and then try to assign a value to transfers of rights to those sites. The reasonable return analysis is for the building as it exists at the time of the application. What does that mean? The commission generally looks at the building's condition and situation. We can evaluate reasonable alternatives and investment where necessary to address government violations and to increase income, such as to rehabilitate apartments. The best way to think of this is we can consider alternatives that theoretically could be approved as appropriate. So reasonable expansions, rooftop additions, rear yard additions, that sort of thing can be considered. Although the law doesn't address how to deal with the costs of these renovations, the commission historically has allowed reasonable renovation and repair costs to be added to the 2% depreciation allowance. Finally, you can also consider the possibility of reasonable new development on the lot. The lot's big enough, another house or whatever that might fit on a lot. The third factor concerns the use of the property. Is the building no longer adequate, suitable, or appropriate for carrying out the current or historic charitable uses? Because nonprofit owners build structures or use structures to facilitate nonprofit use, they aren't driven by the potential profitability of the structure. The law recognized this and asked the commission make a determination that the building is no longer suitable for carrying out those charitable purposes. The commission looks at the charitable purposes currently occurring at the building and the charitable uses at the time the owner acquired the building, if the nonprofit owner is continuing to use those, pursue those purposes. The law provides no additional definitions or explanations for what that term, no longer adequate, suitable, or appropriate, means. The commission historically has looked at both the physical condition and the limitations of the building at issue and the financial impacts of addressing those conditions. It's important to note this factor is not at all formulaic, like the reasonable return analysis arguably is. It's very fact sensitive. At this juncture, I want to mention something that you may hear about called the judicial nonprofit hardship test. As you will recall, the first factor of the hardship test was that the owner was entering into an agreement to sell or lease. That the judicial test was created by the courts to address a situation where that wasn't happening, where a nonprofit was doing the work, the redevelopment, or the extension itself, and not selling or leasing the property. The judicial test is relevant to our discussion because the commission has interpreted this judicial test to be essentially this third factor I was talking about, plus the fourth factor, which I'll talk about in a minute. Therefore, hardship situations that have involved the judicial test provide insight regarding what the meaning of no longer adequate, suitable, or appropriate means. The judicial test asks, does maintenance of the landmark either physically or financially prevent or seriously interfere with carrying out the charitable purposes? This test was first enunciated in 1968, so again, early in the commission's history, in the Snug Harbor case. That case, just to give you a sense of how it arose, involved Sailor Snug Harbor in Staten Island, a group of Greek Revival individual landmarks built in the early to the middle 19th century. The buildings were used to provide housing and other services to retired seamen, and in the 1960s, the nonprofit that owned them and operated them felt they were no longer adequate and wanted to replace the historic buildings with contemporary up-to-date dorms and other facilities. They applied to the commission to demolish the buildings. The commission denied their request, and the organization sued. And one of the claims they made was that the absence of a hardship provision covering their situation made the law unconstitutional. And the courts said, no, we can fill in that gap, and created this judicial test for situations like this. And what the court sent the case back to the lower court to resolve what it called subsidiary questions, and it listed 3 of them. Does preservation of the building seriously interfere with use of the property? Are the buildings capable of conversion to useful purpose without excessive cost? Does the cost of maintaining the building without use entail serious expenditure? The court stressed that this was a fact-sensitive inquiry in light of the purposes and resources of the nonprofit. Note, the answers to none of these questions is determinable of the outcome. Rather, there's an in-depth, holistic analysis of the facts and circumstances. There was no final resolution of that case. As many people know, those buildings are still there. The city purchased them a few years after the lawsuit was commenced. The following are some examples of the situations where the commission has applied this judicial test to help you think about how the no longer adequate, suitable, what that means. The Marymount School case. In that case, the school wanted to add a gymnasium to the building because physical education was deemed essential to the purpose of this all-girls school curriculum. The commission denied the C of A for the addition, but found that a hardship existed. St. Bartholomew's, apologize. The church claimed the existing community house could no longer accommodate its growing charitable uses, and the building couldn't be expanded. so they said, and they needed to demolish the building and build a high-rise with residential facilities and church facilities in the bottom to pay for that expansion. The commission denied the hardship, finding the historic building could be appropriately expanded and reconfigured, and that the church hadn't demonstrated it couldn't raise sufficient funds to pay for the work. And finally, in St. Vincent's Hospital, St. Vincent's claimed that the existing level 1 trauma hospital was no longer adequate, and up to, to facilitate those kinds of things it needed to be the city's only level 1 trauma hospital. They asked to demolish a contributing building nearby where they were going to build a new hospital. The commission found that the existing facilities were inadequate and found a hardship. Ultimately, St. Vincent's went bankrupt, and the O'Toole building, which was the site, is still there today. The fourth factor and final factor, it's pretty straightforward. It requires that the prospective purchaser or tenant seeks and intends in good faith to move immediately to demolish the building for the purpose of constructing a new building on the site with reasonable promptness. There are no specific timeframes for this, but a good faith intention and ability to move forward immediately have to be demonstrated. That completes my discussion of the test. Let's talk about the process. 309 specifies a number of steps and timing for each step. The process includes an opportunity after the commission has found a hardship exists for the commission to find an alternative purchaser or tenant that will preserve the building, or an alternative for the city to acquire protective interest. The maximum time frame for this whole process from application to the end of this is 380 business days from the complete application. This lays out the entire process and time frame. I will break it down to make it easier to see and understand. Note with regarding time frames, all time frames are in business days, but also that applicants can and have waived their rights under these time frames to give themselves and the commission additional time to deal with the application. The hardship process anticipates a two-phased application, whereby there's first a C of A application to determine if the proposed work is appropriate. And if that application is denied, the hardship application follows. However, where the applicant seeks to demolish the designated building, it's common for the applicant to concede their proposed work is inappropriate and just file for the hardship. Once the application is complete, the commission must hold at least one public hearing. Typically, there can be more, and there can be many public meetings. Commission has 90 business days to act on the hardship application. If the commission determines the applicant has failed to demonstrate a hardship, the application is denied. I know here that Charter Section 3021 establishes a special hardship appeals panel to hear appeals by nonprofits from denials of their hardship applications. I'm not going to talk about that today. If the commission finds the applicant has demonstrated a hardship, it makes a preliminary determination of insufficient return. This triggers a process and time frame for the commission to find an alternative buyer or to have the city acquire a protective interest in the property. The commission has 180 days to find an alternative purchaser who is willing to purchase the property on, quote, reasonably equivalent terms and conditions. If it does, the statute allows for a reasonable time for the purchaser and this new buyer to enter into a contract and close on the deal. However, if no alternative purchaser is found, or the alternative purchaser fails to enter the contract or never closes, the commission has 20 business days to send a request to the mayor to acquire the property. The mayor then has 90 days to consider this request, and if it decides it wants to pursue condemnation to acquire an interest, it sends a letter to that effect. If the mayor does not give that notice, the commission then issues what I referred to before as the notice to proceed, which is the ultimate approval for the demolition or other inappropriate work to occur. The work must be done by the purchaser with reasonable promptness after the notice to proceed has been issued. Issuance of the notice to proceed does not eliminate the commission's jurisdiction over the property. If the property is in a historic district, the commission's jurisdiction remains and it still has the authority to regulate what comes next on that parcel. If the property is an individual landmark, the commission will have to evaluate whether the scope of the work authorized by the notice to proceed eliminates or undermines the reasons for the designation. Obviously, demolition of an individual landmark probably means the site no longer has any significance. In that situation, the commission has de-designated the site. There could be a situation like, for example, if we had an individual landmark asking for an addition, like the Marymount School, where it was the hardship was approved, the commission would evaluate whether this inappropriate addition was so damaging to the integrity of the building that the de-designation was necessary. So with that, commissioners, I'm happy to answer questions or any clarifications.
Oh, Commissioner Goldblum?
Got a few. Okay. All right. In general, when a building is deemed to be or unable to produce the revenue that would meet the standard, the 6% return, if the reason that it cannot meet that return is due to actions of the owner itself, in other words, they didn't maintain it or they didn't, keep it up, how does that factor into the determination of the meeting of that amount of return?
Well, I think it's one of the factors the commissioners you could consider. If and then the question, if it was, I guess that's all I should say. It's a factor that you can consider, but you have to consider all the facts. It's not just, oh, the building's in bad shape, therefore it was intentional or whatever. You have to actually consider what the circumstances were.
Got it. Is there any distinction within our regulations that pay any special deference or attention to the fact that a building is owned by a religious institution as opposed to a different kind of nonprofit? And I'm asking more about, like, how would our law intersect with free exercise of religion law?
Well, there's no, other than a prohibition against regulation of interiors of houses, of places of religious worship, the landmarks law is silent on religious organizations being treated any differently than any other property.
Okay.
And there have been cases, just to be clear, there have been cases where designation and regulation have been found not to violate, the religious rights of property owners.
Great. The alternative purchaser provision, is the commission required to find a purchaser, or may it find a tenant?
The law requires that the alternative, the alternative person is willing to agree to, and I quote, identical interest that the purchaser is or that the other person in the contract is agreeing to. So, for example, I mean, sorry, that's totally opaque. So if I'm an owner and a nonprofit owner, I'm agreeing to sell this property to someone, the alternative purchaser has to be willing to buy the property in whole. Has to be. If it's a lease for 20 years, it has to be a lease, or 50 years, it has to be a lease for 50 years. The law is clear. It says an identical interest.
And in that case, I'm assuming from the way that you've worded it, the buyer has no veto power, or the seller has no veto power? We say,
Correct.
Here's your
Correct.
buyer, suck it up, get married. That's it. They have no choice.
That's right. I mean,
Or they
correct.
could choose to not demolish the building and do their own plan.
Right, again, this alternative purchaser has to be willing to agree to an identical interest, and the terms and conditions have to be reasonably equivalent.
But under those circumstances,
That's right.
they have to take it.
Correct.
And is it possible in this venue for you to talk a little bit more about the hardship panel and what that?
I can only say that the hardship panel was, for those of you who are old enough to have been here in 1989, when the new charter came, there were two provisions on the charter revision. One, do you want this new charter for the whole entire city of New York? Second provision, should the Landmarks Commission have a hardship appeals panel? And
Wow.
it was passed at that time. And it was very briefly constituted. It's 5 mayoral appointees. It was very briefly constituted, but I believe it has never been constituted after 1995. So it doesn't exist right now. It needs to have the mayor appoint people, and then it has to be.
How would that affect the timeline?
Well, it's one of those you're talking about a theoretical.
A theoretical situation where theoretically an applicant was told by the commission that they weren't allowed to do it, et cetera.
I would just say I don't think it's determinative at all. But in other words, if it didn't exist and it wasn't that because it hadn't been constituted, I don't think that would affect necessarily the outcome of the case. So remember, if the commission denies an application for a hardship and the person says, I want to appeal to the hardship appeals panel, but it doesn't exist, and it may take a year or whatever that's not going to
Clocks wouldn't stop, or clocks would not stop.
Well, there's no clock at this point. In other words, there's an appeal process that would have to be constituted, and then they theoretically they would appeal, but who knows how long it would be. So I think the reality is people wouldn't wait, but I can't say. I can't say.
All right, so okay, got it.
Unknown, it's a completely unknown situation right now.
All right, thanks.
Okay, Commissioner Ginsburg?
Can we get a copy of your presentation for future thought?
The answer would be, you can watch it on YouTube. I mean, the issue I have with just this is that a lot of it is the commentary. Obviously, that's more important. So to the extent that you may want to review this, I'm happy to talk to you about it. Yeah.
Thank you.
Any other questions? Okay, great. Thank you, Mark.
Thank you very much, Commissioners.